Each year, thousands of criminal cases are heard in courts around Australia. Here, some of the most serious crimes are heard before judge and jury. This is where justice is done. Now, for the first time, cameras have been allowed to witness a major criminal trial.
He wasn't bleeding.
And have you ever held a firearm?
How does it prejudice his defence?
No, Your Honour, see, that's the problem.
On trial is Jason Courtney, 33, a sheet metal worker from Western Sydney. He stands accused of holding a gun at Paul Magyar's head and threatening to kill him.
He had the gun at my head. He said to me, he goes, I know how to use this.
Key witness Craig Gladstone supports the accusation.
I heard, I'll shoot you.
Sure evidence is a pack of lies.
But in defence, Jason Courtney says he was the real victim.
As I looked up, I started receiving punches to the face.
You're telling the truth?
Yes.
Where's the bullet?
If found guilty on 3 firearm counts, possessing, using to intimidate, and firing an unlicensed firearm, Jason Courtney faces 14 years behind bars.
How do you plead to these charges? Guilty or not guilty?
Not guilty.
12 men and women have been chosen to decide Jason Courtney's fate.
The anxious bit is, like, which way is it going to go? Which way am I going to go when it's finished?
Now, out on bail, Jason has already served 10 months in jail on remand.
I've lost my job. I've gone to jail for 11 months. I lost 11 months of my life. It's not just affected my life, but my mum, my dad, my brother, my sister.
Jason has refused an offer to plead guilty to one of the charges. He now risks a longer jail sentence if found guilty at trial.
It's a fight from start to finish. The Crown and the defence are mortal enemies in court. It's adversarial. It's a fight to the death.
Because if the gun goes out, then I think that the Crown would probably have to go away and reconsider its case. My function in this trial is to ensure that whatever evidence does go before the jury, it is admissible and does accord or comply with the rules of evidence.
What we really have here in this trial is 3 trials taking place all at the same time. We have a trial in relation to count 1, a trial in relation to count 2, and a trial in relation to count 3. And what that means, members of the jury, is that the fact that you might reach a particular verdict on one count does not mean that you automatically reach the same verdict on the other counts.
It is, in effect, a contest between the prosecution and the accused, but it's a contest about ultimately one issue and one issue only. Has the prosecution proved the guilt of the accused beyond reasonable doubt?
Yes, Mr Crown.
Thank you, Your Honour. I would ask that the officer distribute copies of the indictment for each of the jurors.
It's part of the tension, to a certain extent, about being a prosecutor, that you have a story to sell and a position to put, which is the case, Mr Magyar's case.
For Mr Paul Magyar, the principal, but not only witness in this case, Friday the 19th of May 2006 was a bad day. He attended a funeral and a wake of a friend of his in the Singleton area, and later in the evening, the accused man presented a pistol, firearm, to him in the toilets at the Caledonian Hotel in Singleton. This trial is about that afternoon, rather that specific evening in his life. He's what's called in legal terms the complainant, the person who makes the allegation.
You? Yes.
Paul Magyar is a rigger from Singleton. He was attending a friend's wake when he first encountered Jason Courtney in the hotel bar.
Do you remember what he was wearing?
Dark coloured singlet, jeans, necklace with a pair of gold boxing gloves on.
And why do you remember the jewellery?
Oh, because it being gold, it stood out quite well.
Did you like it?
Not really, I thought it looked tacky personally.
Can I show you this item? Are you able to comment on whether that appears to be similar to the jewellery you saw on the accused's neck?
Yes, it was.
All right, I'll tend to that. Did you then watch the football match?
Yes, I did.
And what did you do when the game was over?
Went to the toilet.
Okay. Do you see that picture?
Yes.
That seems to be taken looking down at a basin and a urinal area, is that right?
That's correct.
To the left-hand side of the picture, an entrance into the cubicle where the struggle occurred.
That's correct.
Is that right?
That's correct.
And what was the accused man, Mr. Courtney, doing when you walked in?
Yeah, he was going to the toilet.
What's the next thing you saw or heard?
It's hard to say. I heard a clicking sound and they said to me, he goes, I know how to use this.
And what did you see?
I saw him put a hand down beside him and saw like a gun, sort of like cocking action.
And was he holding it in any way?
When I turned around and noticed that he was holding it at my head.
Show us how his arm appeared to you.
Not like that.
Just keep the pose if you would. You've got a bent or cocked right arm.
Yeah.
Is that how you saw his arm or?
Yeah.
When you say you heard this click, what was the accused doing when you say you heard that?
He had the gun at my head.
And did something happen after that?
Well, after that, I noticed that Craig was standing beside him. He must have come out of the toilet. I didn't know that he was in the toilet. Craig grabbed his hand and I grabbed him and we pushed him in the toilet. Craig was bending his arm back and discharged and it went off near my left ear.
Had you ever heard a noise like that before?
Only in the movies.
Did you strike the accused?
Yes, I did.
Hit him? And where did you hit him?
In the face.
And why'd you do that?
Because I was shit scared.
Did he strike back or hit you or grapple?
No.
I
Well, not that I remember, no.
What's the next thing that you remember happening after that?
I remember walking out of the pub or out of the toilet. I noticed that my shirt had bloodstains on it and I walked straight home.
What is your feeling or feelings, if any, towards the accused person?
Well, I object to that question. How is that relevant, Your Honour, to the jury determining the guilt or non-guilt of the accused as to how this witness feels about him?
Yes, I reject that question.
Yes, Your Honour, please.
In Chief, Mr Crown.
Yes, thank you, Your Honour. That's the evidence in chief. It's certainly a relief that the first of the main witnesses is finished, and he was a difficult witness to communicate with in the sense that he's a man of few words, but also quite intense and emotional in his own way as well. And unlike my instructing solicitor, I didn't have the rapport with him that he had.
Instructing solicitor Daniel Lewis worked closely with the key witnesses before the jury on a first trial was discharged.
There were times between the last trial and this trial that I was afraid that they would just say, listen, this is all just too hard, and walk away. And if our witnesses walked away, we wouldn't have a case and the accused would walk.
Now, Paul Magyar will again face intense cross-examination by defence barrister Peter Larvac.
Being a defence barrister is more like being a guerrilla fighter. You try and inflict damage on the other side, and then you withdraw, then you try and inflict damage again. What this case is all about is that you attempted to rob my client of this gold necklace that he was wearing at that time, didn't you?
Was it the gold tacky necklace that I put in evidence yesterday? Is that the one that you're talking about?
Just answer my question.
No, that's incorrect.
No. And you see, when you attempted to rob him of this necklace, you assaulted him physically with your fists, didn't you?
No, that's incorrect.
And your friend, Mr. Gladstone, hit him in the face with an object that was like a gun, isn't that right?
That's incorrect.
Can you tell the ladies and gentlemen of the jury what happened to the gun, if there ever was a gun?
I don't remember what happened to the gun.
Well, if this incident had occurred, there is no way on earth that you would ever forget it. It would be indelibly imprinted on your brain till the day you died. It wouldn't be a case of I can't remember.
No, because I'm trying to go through stages, going to a psychologist to forget this situation.
See, you can't remember because you're telling us a pack of lies, aren't you?
That's incorrect.
In those circumstances where you've told us you're shit scared, you could have died, gun's gone off, what did you then do?
I left the hotel and went home.
The two of you had just overpowered him and you could easily have held him there in that cubicle before the police arrived. Is that right?
If I was thinking straight, yes, I could.
And you made no attempt to do so, did you?
No.
You let him go.
Yes.
Yeah. Now, would you agree that if you were scared for your safety because of this situation, it would stand to reason, would it not, that all the persons who remained at the hotel could have been in mortal danger from the man that you had let go? Do you agree with that?
Possibly, yes.
And those people, they included your wife, didn't they?
They did.
Do you love your wife?
That's not a appropriate question.
Please answer the question, do you love your wife?
Do you love your wife?
Please answer my question, do you love your wife?
You'll have to answer the question. No, it hasn't been objected to by the Crown. In the context of the case, it's a proper question to ask. You'll have to answer the question.
Yes, I do.
Yeah. You told me that you were thinking about self-preservation.
Yes.
That's right. Well, what about the preservation of your wife?
That's why when I got home, I rang her.
Well, ringing her doesn't help much, does it?
I don't know, does it?
Well, wouldn't it have been better to go and physically protect her yourself, pull her by the arm and get her out of harm's way?
If you're thinking logically at the time, if you've got 20/20 hindsight, yes, it would have been the logical thing to do. And calling the police would have been the logical thing to do.
The jury's going to think to themselves, well, Christ, if that's true and all his mates were there that night, why on earth did he run away from the hotel when he could have gone and told his mates what had happened? Why did he run away? Why did he leave his wife in harm's way to a maniac who was loose, who just nearly killed him and his mate? The gun was still missing. Why not call the police? Why not tell the managers? Why run away? The only reason he ran away is because he was guilty. He committed a serious criminal offence against this guy with his mate.
In chambers, the defence team assess what's now been 2 days of cross-examination of the key witness, Paul Magyar.
Yeah, he just sat there like that with his head down and done these ones sort of thing. Yeah. It's you can't sort of show your emotion because you got to keep your face, you got to keep your head together like in front of the jury and all that like. So it's hard to explain because I try not to look at him. Even when he walks in and they say, oh, this is Mr. Magyar coming through the door, I just look at the jury and I don't look at him even when he's in the stand, I look at the people asking him the questions, and when he's answering, I look at the jury.
Next morning, the defence and prosecution argue the admissibility of evidence in the absence of the jury. This trial within a trial is known as voir dire.
Another ground rule that the trial contest is subject to is that only relevant and admissible evidence can go before the jury.
His Honour is going to have to make a ruling on about 3 or 4 different things. Principally, defence want certain evidence out, Crown wants certain evidence in.
Most particularly in this trial, the evidence of the gun, which is being relied on by the Crown in the indictment, which is the paper with the charges, that has been challenged by us, and we're saying that any evidence with regard to the gun should go out and should not be before the jury.
The admissibility of the gun, the admissibility of the hole in the ceiling.
Yes, the admissibility of
the tendency
evidence for the Kodak shop, and the admissibility of the swabs taken from a gun, and the results of those tests.
Crown won't open on those
Arguments
areas
about the admissibility of evidence will continue throughout the trial.
and we'll just have to do it when we can in the trial.
Yes.
The jury returns to hear the second key witness, Craig Gladstone, who had been with Paul Magyar at the wake. A successful businessman from Singleton, Gladstone was the only other person in the toilet when the struggle took place.
I walked out, and as I was walking out towards the door, there was a bit of noise. Some people raised voices at each other. I sort of looked and then just kept going.
And what happened after that?
As I walked out and went to go around the corner, I heard, excuse the language, I heard, "I'll shoot you."
How did you feel when you heard that phrase?
I stopped, turned, and when I turned, I saw this gentleman actioning with what looked like a pistol to the side of Paul's head.
Can you describe the gesture that you saw?
This gentleman was standing to my right and with his hand up to the side of Paul's forehead.
And what did you do when you saw that?
I went towards him and I grabbed the pistol, and when I grabbed it, I pushed it into the air, basically above our heads, and I squeezed down and twisted real hard on what I had in his hand. At that moment, I heard a loud bang.
Did you strike the accused man?
Yes, I did.
And why did you do that?
To get the gun off and basically stop what was going on.
Did you strike him more than once?
Yes, I did.
And where did you strike him?
More than likely around the face.
And what did you do then?
After I left the toilet, I then looked and realised I had something in my hand that looked like a pistol. I then walked around behind the bar, and behind the bar was some squashed beer cartons. I then put it down behind the beer cartons, and I told Amanda...
You're having a dialogue with your witnesses. You're building a case, like you're building a wall against the accused person. You're ideally attempting to do that in a way that's clear and comprehensible for people.
Yes, Mr. Loveck.
Now Craig Gladstone's story will be attacked by the defence.
You then pistol whipped him, and when I use the word pistol whip, you struck him with that pistol across the face, didn't you?
No, it's incorrect.
You told the ladies and gentlemen of this jury that the accused used words to this effect: "I'm going to shoot you."
That's correct.
Was that said in a raised voice?
Most definitely.
Okay. At that time, you must have feared that the man in the toilet, Paul, that his life was in danger, correct?
At the time, I didn't know whose life was in danger. It wasn't until I turned and saw this gentleman with the pistol to Paul's head.
Okay. This must have left a very deep impression on you.
Certainly did.
Yeah. And that, I suggest, is something that you'll never forget.
That's correct.
That'll be with you till your dying day, would it?
Yep.
If it's true.
Definitely true, and
Okay.
yes, it will.
This was you lead them down a path, and once you've led them down far enough, you slam the gate shut and they can't move. Please take out your witness statement. Please show me where that's recorded in your witness statement.
No, it won't be.
It won't be.
Not in that manner or those words, no.
Well, see, I suggest to you that the reason there is this massive discrepancy between what you've told the jury in your evidence and what you told the police is because it never happened. Words like that were never said.
Yes, they were.
Magyar claimed that he said to him, "I know how to use this." And it doesn't bear any resemblance to the words, "I'm going to shoot you." So we've got two witnesses who are quite substantially and significantly contradicting each other on very important matters, crucially important matters in this trial.
To support their case against Jason, the prosecution needs to introduce proof a gun was fired in the attack. No bullet was found, but a bullet-like hole was discovered in the ceiling. The Crown will argue that ballistic evidence should be heard by the jury.
It's very important for the Crown case because defence will be wishing to say to the jury later on in their final address, how can you rely on Mr. Magyar when you've got no independent evidence of clearly established of a bullet hole? Now, you've not examined that site yourself.
No.
Are you able to comment on that hole in terms of its size in a later photograph, number 22, as to whether that was consistent with the impact from a bullet of the kind discharged from the unique pistol?
Yes, well, if it is a bullet hole, then it is definitely not a stable one. So if it is a bullet hole, it has been caused as a result of an unstable bullet, which means that it has impacted something first, or there's been an interruption before it's hit.
And to use a lay term, ricocheting onto another surface?
Yes.
You would therefore require to see impact damage from that projectile inside the toilet somewhere.
Somewhere, or it's possible that it has impacted with a jacket and a button, or some form of clothing, or...
Nobody was
or
injured with a firearm or suffered any
damage to their
clothing,
clothing consistent
yeah.
with a firearm, but there is evidence from Detective Senior Constable Kendall that he examined the toilet and said that he could not locate any damage inside the toilet which was consistent with damage sustained by a small calibre firearm.
If I'm to rely on that,
Well,
which,
I'm asking you to rely on that.
then that hole there needs to have been caused by an unstable bullet.
And if you're asked to assume that there was no impact damage found, then that would exclude the reasonable possibility.
Yes, if there's no interruption, yes.
Do you have any more questions, Mr.
No.
Brown? You don't have any questions, do you?
I think you've just done my job for me, Your Honour. Thank you very much.
Well, Mr. Crown, I mean, that's the end of the matter, isn't it?
Yes.
I mean, the witness's evidence that she has said that she will now exclude the reasonable possibility, being armed with the information that there was no projectile impact damage found inside the toilet.
Yes.
And the Crown's stuck with that
Yes. Yes.
evidence. Well, I can indicate that I give a short judgment. As at the last trial, where I excluded the evidence, I propose to exclude the evidence in this trial.
Yes, Your Honour. There's now no forensic evidence a shot was actually fired in the toilet. It's a serious blow to the Crown case.
That's a ruling against the Crown. The jury won't see or hear anything about that, and it's relevant to the third of the charges that's on the indictment, the discharge of the firearm. But it also may impact, I don't know to what extent, it may impact on the way the jury look at the credibility of these first two witnesses generally in terms of the first and the second count.
And today, getting the evidence out of the hole in the ceiling, that was a big bonus for us, because without that evidence, the Crown's got absolutely no evidence of damage inside this very small toilet area where the two main witnesses say the gun was discharged.
But now there is additional evidence that Jason Courtney did fire a shot in the toilet. Corey Fennick was the hotel duty manager on the night. He claims he heard Jason Courtney make an incriminating comment as the accused left the hotel.
Was he by himself when he left?
When he left through the front door by himself, but by the time I got to the front veranda, which I would have been 10 metres behind him, there was someone else there out the front with him, a few metres behind him.
And did they say anything to each other, or what did they do?
I could hear the accused, yes.
Did he say something?
All I could hear is, I've got to go, I've let a shot off.
I'm sorry, Mr. Fennick, but you said it very quickly. What did you hear the accused say?
I heard the accused say, I've got to go, I've just let a shot off.
Now, that's pretty important evidence for the Crown, and I've got to try and do my best to challenge that evidence, test it, and raise doubts on that evidence. He also told us that you were at the rear entry coming out of the toilets when the police arrived. Is that right?
Right.
And when they spoke to you, did you give them a version of events that you saw that night and what you did?
Yes.
Well, would you agree with this, that when you spoke to those officers and told them your version of events, that you said not one word to them about hearing this man say outside in the street, "No, I've got to go, I've just let a shot off," did you?
That was in my statement.
Forget about your statement. You made your statement 8 days later. I'm talking about the 19th of May when you spoke to the police. That's what I'm talking about.
Well, I can't remember exactly what I said to them.
So if you really heard that, if that really happened, do you agree that it would have made sense to tell the police about it?
No, I'm not going to agree to you, no.
Why? It wouldn't make sense.
It's details. You're not going to remember every detail.
That's a very important detail.
Well, according to you.
Well, you don't think it's an important detail?
In your case, this case, yes.
Yeah. Well, if it's an important detail, why didn't you tell the police?
That's what a statement's for, isn't it? Or does this statement mean nothing?
When the police were there, you had an opportunity to tell them, didn't you?
Mr. Lovac, I think that's about the 10th time you've asked that question. How much
I'll
further is this going to go on?
Yeah,
And what further question can you possibly ask? The witness says he doesn't recall whether he said anything or not about it.
The prosecution is now anxious for the jury to hear incriminating evidence that Jason Courtney was involved in another violent incident on the same day.
The Crown is proposing to lead what's called tendency evidence, relating to the tendency of the accused man to act and have a state of mind in a very similar way to the way we will say that he acted on this particular night in the toilets at the Caledonian Hotel, some 4 or 5 hours earlier when he picked a fight with another stranger. Defence in this trial are seeking a ruling that be excluded.
That such evidence would give rise to a prejudgment about the accused, that he would be a person that would be likely to use, possess or discharge.
But that is the very direction that I will give to the jury, the very thing that I will say to the jury. They cannot use this evidence on a propensity basis, that he is the type of person who would use a gun or act in the way the Crown alleges he did on that night. And so, that direction must be given with all tendency evidence.
Yes, Your Honour. In those circumstances, Your Honour, will Your Honour be then limiting their use of it to being evidence of state of mind rather than tendency? Because that's how I'm understanding what Your Honour is saying now.
Well, the Crown's relying upon both. A tendency to act in a particular way or to have a particular state of mind. Why wouldn't it be both?
What I'd be asking Your Honour to do is, rather than admit, if Your Honour is against me on not admitting it at all, is to limit it to state of mind evidence rather than tendency evidence, admitting it on the basis of it being just state of mind evidence rather than...
State of mind evidence is tendency evidence. It's a tendency to have a particular state of mind. That's what the section says. It's either a tendency to act in a particular way or a tendency to have a particular state of mind.
Yes, Your Honour.
Now, you really can't differentiate between the two here.
No.
I mean,
it's incredibly stressful at times because you do have a person's liberty at stake, and I enjoy fighting for my client's rights effectively. That's really what I'm doing when I run a case.
The judge allows the tendency evidence to be admitted. Now the Crown calls Nigel Clydesdale. He crossed paths with Jason Courtney in a Kodak shop. Nigel was picking up his girlfriend Jackie, who worked there. Jason Courtney allegedly complained about the service.
I can remember I heard that man in a loud voice say, don't you work here, don't you know anything? Words along those lines.
And what did they do after that?
And then Jacqueline and I went to leave. Jacqueline said, someone needs to grow up. And I said I wouldn't worry about him, he's nothing but a rude dickhead.
Did you say that to her or to
I said that to her,
accused?
but loud enough for him to hear it.
I see. And where was he, the accused, when you said that?
We were walking out of the side door and he was sort of behind me to my right.
What happened when you went out of the store?
I started to walk across the road. He said, what did you say? I said over my shoulder, you heard me. And yeah, then I walked over, it was just about to unlock my work kit, and he hit me from behind.
Which part of you were hit?
On the right side, out there.
Well, tell us what happened.
Well, I got up, I took a swing, and then he just kept swinging and fighting. And then Jacqueline came over the top with a handbag and started hitting him.
During that fight, were blows delivered by both you on him and him on you?
One by me and several by him.
Did the accused say anything else at all to you that you remember?
Yep, after that, he said, I'll shoot you, I'll kill you, you don't know who you're fucking with. And then
let me stop you there. When did he say that?
After the fight.
All right, and how did he say that to you?
In loud, just going crazy. He was just yelling and shouting it.
Did you keep fighting with him after he'd said that?
No.
Now, if this really happened, that you were assaulted by this man and he threatened you with death, did you go to report this to the police on the 19th of May?
No, I didn't.
Why not?
Well, because he just threatened to shoot me. I didn't really want to mess with the guy anymore.
You see, I'm putting to you, Mr. Clydesdale, that this threat was never made at that time.
Well, you weren't there, were you?
Yeah. You see, he never said anything of the sort to you about wanting to shoot you or kill you, did he?
Yes, he did.
Yeah. What did you and Jason do
An
after
ex-girlfriend was with Jason at the Kodak shop and also witnessed the incident. Under cross-examination, she gives a different version.
At no time did you hear Jason, during that yelling, make any death threat of any kind. Do you agree with that?
Yes, I do agree with that.
nor did Jason at any time during that yelling make any mention of any threat to shoot or any threat of putting a bullet in someone's head. Do you agree with that?
Yes, I agree with that.
He never said anything of the sort?
No.
Thank you. The entire time that you were with him on the 19th of May, at no time did you see any gun on Jason or Jason show you any gun? Would you agree with that?
Yes, I would agree.
And would you also agree that at no time on the 19th of May when you were with him did you observe any obvious bulge in his tight clothing that could have been a gun of some description? Would you agree?
Yeah, I agree.
Thank you. Yes, thank you. I have no further question.
With so many conflicting accounts, it's critical to the prosecution case that the jury hears independent evidence about the gun used in the attack. This includes evidence that the DNA on the gun belongs to Jason. In the jury's absence, argument continues over whether the gun is admissible.
If we can get the judge to rule that gun inadmissible, we're almost home. If that gun goes, the whole case collapses.
After the day's proceedings, Jahan Gabrielle believes she has found a major flaw in the forensic evidence that connects Jason's DNA to the gun.
I've had a revelation.
What's the relevant revelation?
The exhibit that the gun, you know, the exhibit 285113 with that the gun was placed into, the bag.
Yep.
You know how His Honour said if there's blood on the gun, then isn't that a fait accompli, basically?
Yep.
I've just had a look at that exhibit bag again, or the exhibit number.
Yep.
That gun was placed in the same bag as the jersey which had the blood on it.
Oh, okay.
Contamination.
So it could be contaminated by the jersey. Okay. Yeah. So that's another nail in the coffin of the Crown case.
Next day, Jahan argues that all evidence about the gun should now be excluded from Jason's trial.
So where does the contamination come from?
There are three things placed in that exhibit: a gun, a jersey, and a shirt. There is no evidence that that gun was sealed away from those two exhibits. There's no evidence to exclude the possibility that the blood from either of those two shirts, the jersey or the shirt, then made their way to the gun in some way.
Is that a matter that impinges upon admissibility? The fact that there is possibility of contamination, that the evidence is not relevant. That's the only test on admissibility.
Yes,
is it
Your
relevant? The jury will have all that before them. There was a possibility of contamination.
Well, it obviously comes down to the question of relevance,
Yeah.
Your Honour. Absolutely.
There is a search for the truth going on at one level, but it's only a search that can take place within the rules of the game, which is about only admitting evidence that's reliable and on which the jury can properly convict. And really that's what's going on right now. It's a play between proof and truth, and it's a very strictly observed game to ensure the accused gets a fair trial.
I propose to admit the .25 calibre semi-automatic pistol alleged by the Crown to have been seized by police at the Caledonian Hotel on the 19th of May 2006. I also propose to admit evidence concerning the subsequent taking of swabs from that firearm and the evidence of DNA analysis of those swabs. Again,
It's a major win for the prosecution. If the defence had won the argument, the jury would have heard no independent evidence about the gun. The prosecution now calls their expert witness.
I removed the magazine from the well of the pistol, which is the...
Senior Constable McSpadden tells the jury he found a loaded magazine and a spent cartridge in the chamber of the gun.
Then I racked the slide to the rear, and that's when I noticed a spent case fall out of the chamber.
This evidence appears to support the witness claim that the gun had been fired.
Is the back underside of the slider sharp?
There are some sharp
Ballistic
points.
expert Detective Sergeant O'Hagan gives evidence explaining why the spent cartridge might not have been expelled from the gun.
There is something that hasn't been ejected. The way for that to occur is that there's been some interruption in the process of the slide moving backwards and forwards.
Pausing there, What about the holding with force of a human hand on the top of the slide?
Yes, so any interruption, whether it be because the firearm itself isn't functioning 100% correctly, or a pressure on the slide manually stopping it from opening at the time of discharge.
This evidence appears to support Gladstone's evidence that he grabbed the gun.
All right, thank you. Thank you, Ron.
While ballistic evidence only shows the gun may have been fired on the night, the forensic evidence is conclusive. Jason's is the only DNA found on the gun.
There's blood found on the gun, and the DNA in that blood that was found on the gun was Jason's DNA. So to a large extent, the DNA on that gun, which derives from blood on the gun, supports our case that he was pistol whipped and he was struck in the face with that gun by Gladstone, and that's how the blood got on that gun.
That's a most improbable scenario for a whole lot of reasons, not the least of which is the fact that Mr. Gladstone was there for a wake, came to only to the assistance of his friend, respected member of the business community effectively, and not a gun-wielding, pistol-toting mama.
I'd be lying if I say I wasn't concerned. I'm very concerned. As it's drawing closer to the end, I start to get a little bit more anxious about how the outcome's going to come out.
Yes, Mr. Crown.
Thank you, Your Honour. I close the Crown case.
Thank you. Well, members of the jury, as the Crown has just announced, the Crown case is now closed. The Crown has called all the evidence that it proposes to call in support of its case in relation to the 3 counts on the indictment.
The Crown case has now run over 9 days. Crown witnesses have been cross-examined, evidence has been led, there have been voir dires. The defence case is small, it's narrow and tight, but it's very important. So we're now at a different stage in the trial.
And I can cross-examine till I'm blue in the face and do as much damage as possible, but until they hear from Jason, they're going to say, well, OK, why should we acquit him if we haven't heard from him? He's going to have to get in the witness box and tell his side of the story.
I'm been ready to do that since day one, and the more I've heard their stories and that, the more I want to get up and tell my part of it.
I'll now ask Mr. Levac as to whether he's presenting a case. Yes, Mr. Levac.
The accused has been advised of his rights and he elects to give evidence.
Thank you.
I call the accused, Your Honour.
Mr. Courtney, if you come to the witness box, please. It is a fundamental principle of our criminal law and a fair trial that there is no obligation on an accused person to prove anything. The only issue in the contest is, has the prosecution proved its case beyond reasonable doubt?
Do you solemnly and sincerely declare and affirm that the evidence you shall give will be the truth, the whole truth, and nothing but the truth?
I do. Take a seat, please, Mr. Courtney.
I ask you to cast your mind back to the morning, which was Friday the 19th of May, 2006.
The court hears that on the day of the alleged attack, Jason was drinking heavily.
What are you usually like when you are very drunk?
When I drink, I get happy, as I don't drink a lot. When I do, I get very happy when I do it.
Now, we've also heard evidence that at this particular time, you were wearing this very heavy, prominent gold necklace with some boxing gloves on it. Is that correct?
That's right.
Your Honour, could the witness be shown?
Jason claims he was not the aggressor, but actually the innocent victim of an armed robbery.
Now, is that the heavy, prominent gold necklace that you were wearing at that time?
It is.
Could you tell the ladies and gentlemen of the jury what happened?
I felt a hand grab me around my neck and grab hold of the necklace.
Yes.
As I looked up, I started receiving punches to the face.
Well, when you looked up, who was it that was doing the pulling at that time?
Mr. Magyar.
All right. And what was the effect?
Each punch drove me further back towards into the cubicle.
What was the next thing that you remember happening?
I just noticed the man in the light blue shirt standing behind Mr. Magyar with a pistol like this.
All right.
When I seen the pistol, then I lunged out with my left hand to grab the right hand of where he had the pistol.
Yes.
And Before I could get it, he struck me across the face with it.
Okay.
From there, my head went backwards, and the force of my head going backwards, the chain gave way.
Yes.
It fell to the ground and they both went flying backwards into the toilet door, which was open against the wall.
Now, when Mr. Gladstone hit you in the face with the pistol, which part of the face did that pistol connect with?
My nose, bridge of my nose.
Okay, now your face was already bleeding from the earlier blows you'd received.
That's right.
What then did Mr. Magyar do after you noticed that Mr. Gladstone had gone?
As I reached down to grab the chain and looked up, Magyar punched me in the face.
How did those punches feel?
I was seeing stars.
Now, when you were at Singleton on the 19th, did you at any time have a gun on your person?
No.
Have you owned a gun?
No, I haven't.
Did you own a gun at that time?
No.
Thank you, Your Honour.
Now it's up to the Crown to disprove Jason's story.
Mr. Courtney, I want to ask you a few questions. If you're cross-examining someone, you'll firmly put your own case and test an accused case because, after all, you have a position to put. So my starting position is, in the cross-examination will be, well, the accused's account of being a hapless victim in the toilet set upon by these two men is implausible. Your chain fell to the floor. You crouched down to pick it up with one hand, correct?
Yes.
Then you were punched further by Mr. Magyar.
That's right.
And at that time, you were well and truly overpowered.
Yes.
Nothing to stop Mr. Magyar grabbing your jewellery.
No.
It was still there. You grabbed it and retrieved it.
That's right.
You didn't see either men take anything with them of your property when they separately left.
No, I didn't.
Now, I'm going to ask the court officer to show you Exhibit S, which is the pistol that you say you were pistol whipped by Mr. Gladstone.
That's right.
Right, the court officer's showing you part of that exhibit. What I'm going to do is, if you're able to, just have a look at that pistol, which is a unique brand pistol. There's no issue with that in this trial. I'm going to get you to take it in your hand.
Do I have to?
Yes, I'm asking you to. Now, what I want you to do now is, as best you can, replicate the gesture of Mr. Gladstone when you say he pistol whipped you to your face or nose area.
How he was holding it when I first noticed it?
No, when he struck you.
When he struck me, it was like that, straight across the face.
Well, can you just put your hand up so it can be seen? You're holding it in the palm of your hand.
That's right.
You got your finger actually in the trigger area. Is that, do you remember? I'm only saying that.
I wouldn't have a clue.
Well, I'm just asking you, as best you can recall,
how
Mr. Gladstone appeared to hold the pistol.
I couldn't honestly say. To me, I thought it was a black pistol.
Well, please, don't just wait for the questions. Can I just see that gesture again, and can you just hold it?
Well, I don't know how it was. All I can say is I seen it like that. When I seen it like that, I reached out for the arm. I noticed that he had a pistol in his hand. Next minute, it was across my face.
Well, show us what you saw coming. Imagine, assume you're Mr. Gladstone.
I can't.
Why not?
Because I already had been beaten that many times in the face. My eyes were teary-eyed. I had blood pouring from my nose. I wasn't seeing 100% perfect.
You're telling the truth?
Yes.
What I put to you is this. What really happened on this particular night of the 19th of May was that you were angry with a stranger, namely Mr. Magyar, who you saw in the men's toilet by himself.
No. Had no reason to be angry with the man. I'd never seen him before in my life, and I wouldn't even know who he was travelling to the court that day. If he sat next to him on the bus, I wouldn't even know it was him.
Well, Mr. Clydesdale was a total stranger some 4 hours earlier, was he not?
They're all strangers. I know them from the incident, but that's it.
Mr. Magyar was at the toilet by himself.
No, he wasn't.
When you produced a firearm that you've seen as an exhibit, and pointed it at him and clicked it.
No, it's incorrect.
It's an old firearm. Would you agree with what it appears to be?
I don't know anything about firearms, so...
When you say that, have you ever held a firearm?
No, I haven't.
Is that the truth?
Yes.
See, it's the case that both Mr. Gladstone and Mr. Magyar made no attempt to rob you this particular night, nor assault you.
Yes, I did.
I do, in conclusion, just suggest to you that you're fabricating your evidence
in relation to what truly happened on this particular night.
No, no.
You were the aggressor. You had possession of a pistol.
No, I didn't.
And you intended to intimidate and threaten Mr. Magyar.
No.
And that the pistol was only produced to Mr. Magyar at his head for that simple purpose of scaring the life out of him.
Not at all.
The pistol that was produced was discharged by you deliberately, consciously.
No.
I see. Excuse me. Yes, thank you.
Thank you, Mr. Courtney. You can step down.
Thank you.
Yes, Mr. Lovey.
That's the case for the defence, Your Honour.
Thank you.
The defence case closes, but Jason's testimony has opened the door for the prosecution to reopen its case. They want to introduce a damning piece of new evidence.
There is a legal matter, and
It's a legal matter.
Yes, and it may be able to be dealt with while the jury has perhaps a customary short
Oh,
break.
well, I should first ask, is there any case in reply?
That's a matter I wish to raise with Your Honour.
All right, well, ladies and gentlemen, if you go, it's 3 o'clock, if you go with the court officer.
We have a witness statement from his former girlfriend in which she said he did own a gun and he had discharged a gun in a very dangerous manner, and she took a photograph of him immediately after that event with this accused holding a black handgun. So it's clear to us that his answers to those questions weren't truthful.
In cross-examination, he said on oath he never held a firearm. It's the Crown's position that the last answer raises an issue for a case in reply in the context of the accused's possession of a firearm at an earlier previous occasion.
Did I give a ruling in the last trial that that evidence was not admissible?
Oh, yes.
As tenancy evidence?
Yes, when agitated, yes.
And what they're trying to do by calling evidence in reply on this is simply trying to get evidence in the back door that was ruled to be inadmissible at the last trial.
The photo was ruled out of evidence by Judge Marion during the first trial because it was taken 5 years before the incident.
The criminal justice system has allowed a body of legal rules and principles relating to the admission of evidence to come into existence, whether it's the Crown or the accused. If they seek to tender evidence, it must comply with those rules. It must be admissible under the law. You asked that question knowing what the correct answer was.
Well, yes. It was cross-examination.
Yeah. What was the relevance of asking him whether he'd ever had a gun before?
To address the issue relating to the accused's abhorrence with handling the firearm and his answers in relation to unfamiliarity with the firearm, and only for that purpose.
Mr. Crown, there's a major problem here, isn't there? When the accused said no, you should have asked for the jury to go out and for you to agitate that question in cross-examination, because it was never put to the accused. He was never given the opportunity. He may have just simply forgotten about it.
Well, I didn't want to agitate that at that time, Your Honour.
Why not?
Well, I was somewhat taken aback by the answer, Your Honour.
Yes, and then what you do is you say, Your Honour, before I proceed with my cross-examination, there's a matter I need to raise because I anticipate there may be some objection to my next question.
Yes,
Can we deal with this in the absence of the jury?
I understand that,
Your Honour, what I propose now to put to the accused is the contents of this statement.
I take Your Honour's point as to an available preferred course, but in my respectful submission,
But he has finished his evidence and he stepped out of the witness box. I cannot force him to go back into the witness box. And the defence don't have to require him to go back into the witness box. And what the defence would simply put on this application is the Crown never put it to him. You had it in your hand. You knew.
Yes, it could be...
The contents of this statement.
Well, that's so, Your Honour, but...
The judge did say we should have put it to him in the box, but both Tim and I have been very cautious to not say anything that could lead to any applications to discharge the jury. So we've been as conservative as we can in what the jury hear and see.
The Crown position is that it be entitled to reopen a case in reply and that there is no prejudice to the accused
What
in
if the
doing
accused refuses to go back in the witness box? Who do I ask? Miss Gabriel? Will the accused consent to go back into the witness box for this matter to be put to him?
Well, Your Honour, I don't know. It's going to depend on Your Honour's ruling. If Your Honour rules...
Well, I've asked that question because that is relevant to my ruling. You see, the Crown can't force him to go back in the witness box. I can't force him to go back in the witness box.
The problem is...
The only way that it can be remedied, if that is, for the matter to be put to him, is that he would consent to go back in the witness box. Does he so consent?
No.
Thank you. Mr. Crown.
Well,
there is prejudice to the accused.
Well, I don't know.
See, if you had put the matter to him, he may have said, "Oh yes, that's right, I remember now."
Yes.
Which then would have not required the Crown to lead a case in reply, with all the prejudice that goes with it, that it's the last evidence in the case that the jury hears.
Your Honour, please. There was a legitimate basis to do it in the way I sought. He overruled me on that, and that being the case and that being right, I probably should have taken the course that His Honour said, I guess. But yeah, it's just one of those things that happens in a trial. Perhaps an error. But I don't know that the evidence and what you do with it was going to be so significant in this case. Because as His Honour said, that's what happened in the toilets that was really the issue.
The jury will now never see evidence that Jason Courtney appeared familiar with guns.